Did you know that you, the employer, can get sued for failing to accommodate an employee, even if they never formally asked you to? By the end of this video, you'll know how accommodation laws actually work and why, but they didn't say anything won't hold up in court. Let's say an employee's performance suddenly drops. They start missing deadlines, taking more time off, showing up tired, distracted, or even agitated. You pull them into a meeting. You talk about expectations. You document it as a performance issue. Then a month later, you're facing a claim under the ADA or the PWFA. Instead of asking, is there something deeper going on? You saw a poor performance issue. The law saw a possible medical or pregnancy-related limitation, and now you're in the hot seat trying to explain why you didn't offer the required legal employee accommodations. When a situation happens like this with an employee, when you start seeing these signs, you're required to initiate what's called an interactive process under the ADA and now the PWFA and other laws. Not after they spell it out, not after they bring a doctor's note, but when you observe something that suggests a medical or pregnancy-related issue is at play. You don't need a crystal ball, but you can't play dumb either. Here's what courts want to know. Did you notice the signs? Did you ask any questions? Did you offer support? Did you initiate the interactive process? If the answer is no, even if the employee didn't come forward, you're exposed. This gets employers all the time, especially with mental health, chronic conditions, and pregnancy-related needs. Too often, employers assume if they need something, they'll just ask. But in the eyes of the law, that's just not enough. The ADA and PWFA don't require magic words. They require awareness and action. Here's what that means in practice. If an employee is pregnant and starts struggling with physical demands, you don't wait for a complaint. If an employee seems overwhelmed, unfocused, or frequently absent, you don't just chalk it up to an attitude. If an employee mentions medication, treatment, or stress, you need to ask questions and start documenting. Courts and the Equal Employment Opportunity Commission will want to see when you became aware of a potential issue, what steps you took to explore accommodations, whether you applied the same approach to others in similar situations, and where all of that is even written down. If your answer is, we didn't think they needed anything, or worse, they never asked, that won't protect you. It'll sink you. Let's look at some common scenarios. A frontline worker mentions they're undergoing chemo. A warehouse employee casually says their back pain has gotten worse. A new hire tells you that they're pregnant, but says they're fine for now. In each of those cases, the law may already consider you on notice. Your job is to engage in a conversation, not wait for a formal request. Ask, would any adjustments help you continue doing your job? Is there anything we can do to support you? Then document that interaction, every time. This also applies to the PUMP Act, which requires employers to provide break time and private space for nursing employees, even if no formal request is made. And remember, even when accommodations aren't feasible, you still have to go through the process. It's the good faith effort that matters. You're not being asked to diagnose anyone, but you are being asked to document and respond in good faith when accommodations might be needed. That means opening the door to a conversation, offering a form or process for requests, documenting the timeline of what was said and when. Because if it ends up in court and your answer is, they never said anything, their lawyer's gonna say, that's because they were scared to, and you never made space for that conversation. Support your team, document the signs, start the process. Because silence doesn't protect you from liability, it just builds the case against you. Thanks for watching.